All right. Okay. Well, hang on for just a second. Then we have nobody to record the proceedings yet. Give it a minute.
Hi, Judge, it's the clerk's office. I'm gonna go talk to Court of Claims, see if we can get a hold of Miss Roberts, the court reporter.
Do we have the same person as we had this morning?
Yep, she's the same person and same link. So I'm gonna run out there and see what I can do to get her
Okay.
back.
Yeah, don't worry about it. I mean, I think we're actually a couple minutes early. Yeah, 3 minutes early. No. This thing first. By the way, we have table mics now, so we'll pick you up if you say something from council table. You can thank Jim for that.
They have worked pretty well.
They worked very well. Yeah, it's been great. We did the best we could to explain the needs of a trial court, and one of them is you have to have table mics because people are unaccustomed to just coming up to the lectern every single time they want to say something. Before we get on, why don't you help me out with this? Who's going to be arguing today? My guess is it's probably just going to be one person from each side, although I know there are three motions up. Mr. Vittilio, are you going to be covering all the motions yourself? Okay, that's fine. Great. And from the other side?
Your Honor, John Tuttle. I'll be arguing the MSD, the fifth MSD of the NDOT.
Yep.
Judge, Mike Dittenberg, Attorney General, I'll be arguing the motion regarding the expert.
Okay, all right. So just for planning purposes, before we get the court report on it, Mr. Dittenberg, you're going to be on your feet first. I want to try to clean up these discovery motions quickly. I'm going to decide them from the bench. No, we're not. We're not at all.
We're going to dismiss the motion to compel. We're going to dismiss that.
Okay, so you're just going to withdraw it? I'll turn to you first on that one then. So it's just the expert then? Okay, that's fine. See, you won one already. All right, so I can get rid of this one then. Just to indicate it. Well, I'll give you a chance, Mr. Vittilio, to indicate it's withdrawn. So we'll formally do that on the record, but I'm not going to worry about it. And just to give you a heads up, I'm going to take a quick run before we go to summary disposition and try to describe exactly what I think is left of this complaint. I think it's count one, then a portion of count two, a portion of count three, and a portion of count four. And then I think everything after that's gone, right? That's my understanding.
Judge, I'm bringing in that court reporter right now.
Okay, sounds good. Yeah, we were just going over some preliminaries. I think I'm going to save her some trouble. I think we've got a lot covered. Oh, okay.
If he's talking, we can't hear him.
Okay, yeah. I don't know if you can hear me, but I was just told by our court security officer that the court reporter's here, but she's muted, so I can't hear her.
I'm muted.
Okay, you're unmuted. Great. Thank you, Ms. Roberts. Welcome back.
Can you, the parties in the case, please, the attorneys, can you all tell me your name and what side you're on, in respect to the judge? Are you on the left side or the right side?
Well, let me go to the plaintiff's table first. We're not on the record yet.
Okay, so my name is Anthony Vitilio.
What side are you on of the judge? The judge is left or right?
I'm on the judge's left.
Left.
Okay, what's your name? Anthony what?
V as in Victor, ITTIGLIO.
Okay, who's on the judge's right side?
I am John L.A. Tuttle, Tuttle. Those are all T's as in Tom. And next to me is
Michael Dittenber, Dittenber.
BER?
Yes, ends in BER.
Who's gonna be speaking on the right?
And then Michaela Bentley, B as in boy,
How do you
E-N,
spell Michaela? There's a few names, a way to spell that.
M as in Michael, A-K-A-Y, L as in Larry, A. Bentley is B as in boy, E, N as in Nancy, D as in dog, E-L-E.
And she will not be arguing, as I understand it. Mr. Dittenber will argue the first motion and Mr. Tuttle will argue the second.
Michaela, I'm sorry, can you spell your last name again? B-E-N what?
D-E-L-E,
D like dog?
correct,
E-L-E?
correct. It's a janky German name.
Right, but she will not be arguing today.
I still need her name, Judge, for the
No,
transcript.
that's fine. I'm just letting you know, she will not be arguing today.
Okay,
Okay, are you all set to go now?
yes.
Great. So we're going to go on the record in just a moment. I'm going to talk about each one of the motions individually once we go on the record. For the court reporter's benefit, I'm going to refer to the first motion, but then Mr. Vitilio is just going to withdraw it. So that's going to go very quickly. And then the next two motions will be argued in detail with Mr. Dittenber responding to the first one, and then Mr. Tuttle cleaning up the more complicated one that comes last, okay? All right, everybody ready to go?
Yes.
Great. We are on the record now in case number 20-000-172-M as in Mary, K as in Kathy. This is the case of Atsalis Brothers Painting Company against the Michigan Department of Transportation. We're here today in this long-running case to take up three motions, although I believe the first motion will be withdrawn. So let me read that one and then we'll confirm it's being withdrawn. This is the motion style is October 18, 2024, Atsalis Brothers Painting Company's motion to compel production of documents in connection with its second request for production to the Michigan Department of Transportation. And Mr. Vitilio, I don't mean to speak for you, but I believe you're going to withdraw that motion. Is that correct?
Correct, John.
Very well. Obviously, there's no objection from the defendant, I presume.
No objection, Your Honor.
Very well. That motion will simply be treated as withdrawn. I will enter a very brief order tomorrow indicating that that motion has been withdrawn. Now, let's move to the two contested motions today. We'll begin with the motion dated May 17, 2024. It's the plaintiff Atsalis Brothers Painting Company's motion for leave to file an amended witness list to name an expert. As I understand it, the proposed expert is Greg Johnson, who is the former Chief Operating Officer of the Michigan Department of Transportation. And he's being proffered as an expert, not only in the matters of MDOC contract administration, but also with regard to a special provision for DRB. And most specifically, it says Mr. Johnson is qualified to provide expert opinion testimony on the typical facts and circumstances that give rise to the implementing of a termination for convenience provision and the importance of clear and unambiguous design plans, special provisions and specifications published for bid on bridge painting projects, and the consequences of when the Michigan Department of Transportation terminates a contract for convenience and what compensation is due, and the purpose behind the DRB panel, and opinion testimony on the Michigan Department of Transportation's unilateral termination of the contract for convenience and termination of the DRB panel and refusal to allow the appeal of Atsalis of MDOT's wrongful claim denial. Now, before you make your argument, Mr. Vitilio, I'm inclined to grant your motion. In doing so, though, I want it to be clear that I'm not reaching the conclusion that any testimony Mr. Johnson could offer would be admissible under Michigan Rule of Evidence 702, nor am I indicating that he could not be challenged under Daubert and related cases. But my inclination at this point, since we're nowhere near trial, I'm not sure we're ever going to try this case. It was supposed to be tried last August, but here we are going round and round again, that it's not going to cause any undue prejudice to the defendant. And I would frankly like to see what he's going to say. So if you depose him, then I'll know whether I should exclude his testimony at trial, but it's a bench trial. And at this point, without any testimony from him, I feel like I'm flying blind. So, Mr. Vitilio, that's a long way of saying that you're going to win the battle today, but it doesn't mean that he's necessarily going to be allowed to testify at trial. All right, anything you'd like to say?
Nothing to say given the court's information.
I'm sorry, I can't hear Mr. Vitilio. He sounds like he's very, very, very far away.
Your Honor, nothing to say, given the court's inclination to grant the motion. I mean, we set forth the law. Justice, our amendment should be freely granted when justice requires.
I think that has to do with pleadings, but the same basic deferential rule applies to adding witnesses. I don't see how they can argue that there's undue prejudice here. I just don't see it.
MDOT in their witness list to that point, Your Honor, did identify former MDOT employees. Mr. Johnson squarely falls within that designation on their own witness list. And, you know, just given the unique set of circumstances and facts on this project and the very oft used termination for convenience, not just here by the state of Michigan, but on any given construction project, the contract does say what it says, but Mr. Johnson is going to provide some real flavor into why these decisions are made with respect to terminations for convenience, what a contracting governmental entity looks at when making that determination versus potentially defaulting a contractor, where here that did not occur. Secondly, with respect to the dispute review board, Mr. Johnson will provide the court some really good specialized knowledge into why that process was developed by the state of Michigan on their highway transportation projects, in particular with relation to bridge painting and bridge construction. So, Your Honor, we do believe that there's going to be no prejudice to the department by allowing us to add Mr. Johnson as a witness. Your point about Daubert and your point about whether his testimony is ultimately admissible is understood, but I would ask that you grant the motion.
Thank you, Mr. Vitilio. Why don't I invite you up to the lectern then, Mr. Dittenberg? As I say, I've telegraphed where I'm going, but I want you to rest assured that this is just a method to put this witness in play. You'll have the opportunity to depose him for up to 7 hours. And then if you want to make an argument based on the threshold requirements of 702, I'll be glad to hear it. I'm not bound and determined to have him testify at trial.
I understand that and I appreciate that, Your Honor. With that understanding, I would just like to make the record that with the 4 remaining issues in this case, even as proposed, Mr. Johnson's testimony will not assist the court in resolving any of those issues. The court has already determined the legal effect of the termination for convenience. All that's remaining on that claim is the appropriate amount of damages, which there's no indication that Mr. Johnson has any specialized knowledge in that factual determination. There's no indication that he is able to assist the court in interpreting the painting special provision that forms the basis of count 2. The remaining issues that were raised in the plaintiff's motion relate to the dispute review board, which is an administrative non-binding remedy, which even if MDOT had proceeded to that, that would not affect the claims in this case because it's non-binding.
Is that in the nature of mediation? I know it's an administrative process, but is it like mediation?
What it is, Your Honor, is it's a 3-person board. The contractor selects 1 person, the department selects 1 person, and those 2 select the chairman of the board. And it sits as to review contractor claims after the engineers made a decision as a administrative remedy before proceeding to litigation, but it is non-binding as to both parties unless both parties accept the recommendation.
So it sounds like non-binding arbitration. I'm not saying it is that, but it sounds akin to non-binding arbitration.
It's a newer process to use. It used to be a department had the final say on all claims. It was reviewed through different levels of the department. And this was to give more of a neutral opinion on some of these issues to help resolve them before litigation. And the final issue is the current CMGC contract. And again, Mr. Johnson was not with the department when the department made that decision. That contract is irrelevant to the content of this contract. And if we're going to get into issues related to that contract, we would request the ability to get into issues related to other contracts that Atsalis has bid on or performed.
Thank you, Mr. Dittenberg. I appreciate that.
Thank you.
What I'm going to do with this motion, and this is Plaintiff Atsalis Brothers Painting Company's motion for leave to file an amended witness list to name an expert, is I'm going to grant the motion. I'm going to allow the plaintiff to add to its witness list as a proposed expert witness, Greg Johnson. And because he's being added as a witness, I'm obviously going to open discovery. I don't know whether discovery is still open or not, but I'm going to open discovery for the purpose of allowing the defendant to take the deposition of Mr. Johnson. And then in the wake of that deposition to file any motions prior to trial that the defendant would like to challenge the admissibility of his testimony. I'll note in passing, first of all, that the court has a gatekeeping function under Michigan Rule of Evidence 702. And in exercising my gatekeeping responsibility, I will have to decide first whether Mr. Johnson is qualified as an expert by knowledge, skill, experience, training, or education. Next, I'll have to decide if scientific, technical, or other specialized knowledge that Mr. Johnson has will help the trier of fact to understand the evidence or to determine a fact and issue. And I have real doubts about that, but I don't know until I see what he says at deposition. And then finally, there are the Daubert measures that the testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. I don't even know what version of Rule 702 we're on in Michigan. I'm quite confident I read the current version of the rule, but I think there may be a review of tightening it up even further in light of the fact that Federal Rule of Evidence 702 was very recently amended to emphasize the importance of the gatekeeping function. So in granting this motion, I don't want anybody to read more into my ruling than should be read into it. And that is, I think it's important to give you the opportunity to try to present expert testimony, Mr. Vittilio. And I think it's important to allow the defense to make a record of what Mr. Johnson would say by taking his deposition. And then I'll be glad to take on any motions you want to make. It is not my choice to have an expert come in and testify for a full day or two about every issue in the case if it doesn't serve an evidentiary purpose, okay?
One
Oh,
clarification.
you probably want to come back up to the lectern so the court reporter can clearly hear you.
Just one clarification on that ruling, Your Honor, in addition to opening discovery so that we can depose Mr. Johnson, would the department have the opportunity to name a rebuttal expert after we take his deposition if we determine one is necessary?
You may.
Thank you.
You may. And Mr. Vittilio, I presume you don't object. If I'm going to let you add an expert, obviously they're going to be allowed to add an expert to match if I'm going to let your expert testify.
No objection.
Thank you very much, both of you. That motion is resolved. I'll set that aside, and now we'll move to the main event. And I'm going to offer some comments on this before we get moving, because there's a lot to say both about this case and about the issues being raised today. Now, let me start by taking stock of where we are. This complaint was filed on August 27th, 2020, and it included a number of counts. And I want to make sure that I know what's still left. There are 7 counts in the complaint. And Mr. Vittilio, will you just confirm for me that we're still operating on your original complaint? There's no amended complaint.
Confirm.
Very well. Now, let me see if I can summarize where I think we are. Count 1 for breach of contract is viable, and in fact is not even being challenged today by the 5th motion for summary disposition. Do you agree with that, Mr. Tuttle?
Yes, Your Honor, with the caveat that the court has already ruled on the legal interpretation involved in count 1.
Very well. And Mr. Vittilio, obviously you understand that there's no chance that count 1 will be removed from the case on summary disposition today. You understand that? Very well. Then, as I understand it, the motion focuses on count 2, breach of contract alternative pleading. Count 3, breach of implied warranty of accuracy alternative pleading. And count 4, misrepresentation alternative pleading. And Mr. Tuttle, those are the 3 counts you're challenging today, correct?
Yes, Your Honor, all that remains of those 3.
Right. And I'll talk in a moment about what I think is left and what's not left. And then with regard to counts 5, 6, and 7, they are no longer in play. Is that your understanding, Mr. Tuttle?
Yes, Your Honor, they were dismissed, I believe, on MDOT's 4th motion for summary disposition.
And Mr. Vittilio, I'm not asking whether you agree with that dismissal, but do you agree that counts 5, 6, and 7 are no longer at play in this lawsuit? Thank you very much. Now, let me do the best I can.
I didn't hear him.
Yes.
Okay,
Let me do the best I can now before I invite you one at a time to come up to the lectern and argue. And I'll try as best as I can to explain where we are today. There's no doubt that Atsalis Brothers was chosen as a contractor for a project on the Blue Water Bridge by the Michigan Department of Transportation. There's no dispute that Atsalis provided work on that project for some significant period of time. There's no dispute that Atsalis didn't meet the actual deadline for the contract between the parties that was originally signed. And there's no dispute that the Michigan Department of Transportation terminated the contract by letter dated March 31, 2020, citing section 108.12 of the 2012 standard specifications for construction. Now, after that termination, the defendant invited the plaintiff to submit outstanding costs for compensation. And suffice it to say that Atsalis provided a number in excess of $10 million, if I recall. And the respondent, the Michigan Department of Transportation, was willing to pay somewhat beyond $500,000. In any event, the parties were millions of dollars apart. And so this lawsuit was filed on August 27th of 2020. Now, because of the passage of time and the way that we staff the Court of Claims, this case has gone through the hands of several judges. It was assigned originally to my colleague on the Court of Appeals, Judge Kelly. And then I know at some point, Chief Judge Gleicher had the case assigned. And along the way, each one of those judicial officers made decisions that are not formally binding on me, but I'm pretty committed to honoring those decisions to the very best of my ability. What brings us here today is something styled as the Michigan Department of Transportation's fifth motion for partial summary disposition. Now, as a longtime trial court judge, anytime I see something called a fifth motion for partial summary disposition, it makes me uncomfortable and a bit unhappy because it means that the case has been dragging on far too long and the court has been perhaps too patient in entertaining motions for summary disposition. Be that as it may, this is my first really good close look at the case on summary disposition. So I'm willing to do two things. One, look at it with a fresh set of eyes. And two, write an opinion that I hope will be a roadmap for what I think is the analysis that we'll have to consider when we go to trial. Now, I will indicate that there are two prior decisions in particular. They're exhibits 34 and 35 to MDOT's motion that really, I think, lay out my responsibility here. And in reviewing everything that's come before, I have to say that this looks something like a motion for reconsideration of some earlier decisions, albeit on a more comprehensive record. And when I say a more comprehensive record, what I mean is that the Michigan Department of Transportation is not acting in bad faith in filing this motion because obviously the development of additional evidence could lead to further relief. But as I say, one of my colleagues, and in some cases, two of my colleagues, have already taken a good close look at this case and have left standing count one, albeit with some limitations on it, counts 2, 3, and 4, with some portions of each one of those claims taken out, and then not counts 5, 6, and 7. So let me see if I can understand what's still left. With regard to count 2, I believe that what's happened is that this court, and by that I mean the Court of Claims, not me, has dismissed the Scotch coat and weight limits portions of count 2 because Atsalis failed to submit a timely request for payment. And what's left of it then in count 2, at least as far as I can tell, is the blast cleaning claim. With regard to counts 3 and 4, it's a little bit different. There, at least as far as I can tell, and stay with me for a second while I make sure I have this right. What's left of counts 3 and 4 is the Scotch coat claim, but not the blast cleaning claim or the weight limits claim. So let me stop right there and see if I have that right. Mr. Tuttle, is that right or is that wrong? And you might want to come up to the lectern so that the court reporter can hear you clearly.
Yes, Your Honor, that's our understanding of what is left in those counts.
Okay, thank you very much. And then Mr. Vitilio, if you don't mind, I'll invite you up to the lectern so you can be heard clearly. Is that your understanding, based upon prior rulings of my colleagues, what's left of this case?
That's my understanding, yes.
Great, thank you very much. So let me just finish by observing that I cannot decide this from the bench, much as I'd like to try to keep this case moving. But if I'm going to write an opinion, I'm going to try to write a good opinion that can explain what I think remains and the reasons why it remains and what we still need to resolve at the bench trial. With that, I'm going to turn the microphone over to you, Mr. Tuttle. I'll invite you to come on up to the lectern so you can be heard clearly, and I'll be glad to hear anything that you want to say. You can presume that I've carefully studied the briefs and the prior opinions. It would not be safe to assume that I've read every single page of all the attachments to this motion, because they are as voluminous as any attachments I've ever seen. So with that, welcome to the lectern, and I'll be glad to hear anything you want to tell me.
Thank you, Your Honor. One thing I'd like to mention first is in regards to what you have stated about the motion to amend the witness list. I just would like to clarify that our current understanding is that discovery is still open because there are a few parties left to depose in this case.
That's fine.
Yeah. So just to be clear that yeah. Okay, I won't belabor the point.
And I guess I could ask you this too, because for my planning purposes, we took a run at trying the case last summer and that just didn't work. If you had to guess, when will this case be ready to go to trial? Because I have to block off a fair bit of time.
Your Honor, I would think later this year, towards the end of the year, I would think it's possible. We have to depose, I believe Atsalis still would like to depose the engineer on the project. MDOT would like to depose one of their vice presidents and perhaps a foreman. And then it sounds like we'll be deposing Mr. Greg Johnson.
And you may name your own expert.
And our own. So there's still a fair number of depositions. And as you noted, Your Honor, the exhibits are just voluminous. The records in this construction project, and that is really the basis of why there's so many motions for summary disposition, because it's virtually impossible to include everything in one motion.
Right, and I'm not being critical of you by saying what I said about a fifth motion for summary disposition. It's just
Hello?
Hi, Ms.
Hello?
Roberts. We're having some difficulties right now, so sit
I
tight.
didn't know if you didn't know. I didn't hear anything. Everybody disappeared except me.
Yeah, I'm working on it. Yeah, thanks. Hi, Miss Roberts. It's Mike. They took a recess until we get this figured out, but we're still working at it. I apologize.
Okay, did you catch it right away?
Um, it like when the quarter went black, I told them we've been dark for like 10 minutes.
Oh, okay, well,
They're recessed right now. Hold on. Yep.
okay.
and then we just let that side.
But it's just.
I don't think we have to. That's nice, but limits, obviously. Yeah. Yeah. No, we did a hiking. We went a hike. I haven't done that in ages. What it is. Stuff here and then do that. Yeah, it was good. It's not to do.
Don't stand up, for goodness sake. This is a trial court, much more relaxed here than the Court of Appeals. I keep hearing back there that the recording's in progress, so I thought something had happened, but I guess I'm wrong.
Hey, Judge, it's Mike in the clerk's office. We had some difficulties and lost the Zoom. I am not sure where we were in the proceedings, so Miss Roberts will probably have to tell you where she left off, but it was a few minutes before we figured out what was going on.
That's okay.
It was 2 minutes, because I had, as soon as it happened, I texted the office, and then 2 minutes later, you came on and said, you know, you were fixing it. So
Okay.
Judge, I can tell you the last thing I have. I don't think that you went much further.
Yeah, Ms. Roberts, if you can do that, that'd be great, because Mr. Tuttle's gonna pick it back up, and I know he's perfectly prepared to start wherever you tell him he left off.
No, it was you, Judge.
Oh, it's me. What did I say?
Okay, the last thing I said, I was flowing, and then all of a sudden, poof, everything was gone. It was right, and I'm not critical of you when I say a fifth motion for summary disposition, and then I lost it.
Okay, at that point, was Mr. Tuttle already doing his presentation?
I'm gonna tell you the last thing I heard Mr. Tuttle say. So there's still a fair number of depositions.
Oh,
Then
okay, I got it.
Mr.
Okay. Okay, so it sounds to me like we didn't get into the substance of
Yeah,
your,
that was just before you were saying you didn't want to be critical of the fifth motion.
right, okay. So I think it's fair to say you might as well just start from the beginning. Because I think that was just the preliminary stuff that we were talking about.
Yeah, I agree, Your Honor.
Okay, that's fine. And thank you, Ms. Roberts, for your patience. We've had some problems with these Zoom links, but it doesn't
It's
upset
much
me at all.
harder than being in person, Judge.
Yeah, oh, I understand. Believe me, I was just explaining to our security officer that if we pay our court reporters more, we wouldn't have problems getting people to come in.
Right, exactly. That's why we don't come in court.
Ms. Roberts, believe me, I know it's been a long battle to try to get fair compensation for court reporters. My wife is a certified court recorder, so I have to stay out of all that. But
Okay.
yeah, believe me, I know that if they paid you what you're worth, we wouldn't have any of these problems. Okay, before we go back on the record, let me just tell you, Mr. Vittilio, where we are. Ms. Roberts dropped off a couple minutes before we realized that. And what happened is she read back to us the last thing she had me saying, the last thing she heard Mr. Tuttle saying. And it's fair to say that he hadn't even gotten into his argument before we lost her. We were just discussing things like what we were going to do with the added expert. So I expect Mr. Tuttle's going to start from the beginning and we'll pick it up from there. Ms. Roberts, are you ready to go?
Yes, Judge.
Okay, thank you very much. We are now going back on the record. We lost the Zoom link, but I think we've been able to figure out where we left off. And so, Mr. Tuttle, I'll invite you back up to the lectern and you may start at the beginning if you like, sir.
Thank you, Your Honor. As I was saying, MDOT's fifth motion for summary disposition seeks to dismiss the remainders of counts 2, 3, and 4. In regards to count 2, what is left is the blast cleaning claim after July 23rd, 2019. And the significance of that date is that is the date when they submitted their notice of intent to file a claim. Now, under the contract, to maintain and preserve a claim, they have to file notice of the claim with MDOT. And they have to do it upon encountering the circumstance that is the basis for the claim. Now, their blast cleaning claim is essentially that the contract does not require all of the steel to be blast cleaned. It only requires areas of that steel that are either bare, rusted, or where the coating's damaged.
And just so we can make a record on this, as far as blast cleaning goes, that was step one of the process. And then when the blast cleaning was completed, then there was a three-step coating process behind it, right?
Yeah, yes, Your Honor. So the just for background, the paint is not merely aesthetic. The whole purpose of the paint is to preserve the metal from rust. And it does so by using a sacrificial zinc coating, because the rust will go to the zinc first, and therefore the zinc will rust before the steel rusts. But that only works if the zinc is on the steel. So the coating has to be all removed, and you have to have bare steel. And there's a cleaning standard called SP10 that has to be met, that describes what the surface should look like before you put the zinc on. And so the first step in the process is to remove it, to blast clean it, or to use tools like a grinder to
And
remove
just
it.
to be clear, it's your position that they had to blast clean everything,
Yes, Your
not
Honor.
just a little bit.
Yes, our position is that the contract required full blasting as every other contract. It was a warranted work. MDOT doesn't warranty partial blast cleaning, it warranties full blast cleaning. And so after Atsalis had started late, and done only 7% of that blast cleaning, and coating, because the coating has to follow shortly after the blast cleaning, for the section blast clean. They asked for clarification, because they believed that the contract didn't require them to fully clean and coat. So to be clear, they showed up on the job and fully clean and coat 7% of the steel. And they were late and they had to stop for the winter, and they had only accomplished 7%. Yet they only had half the time remaining to do the rest of the 93%. And so they asked for clarification and said, we believe the contract doesn't require us to do a full job like we just did. We think it's just a partial job. And the response from MDOT was, no, it's a full job. But the court has ruled that that was ambiguous. So the significance of this is that the notice for intent to file claim didn't happen at that point. It didn't happen. It happened half a
When you
year.
say at that time, you mean at the end of the first season, because as I understand it, it's seasonal work because you need conditions that are conducive to doing this right. And so they got into November and it became impossible to go forward.
Yes, Your Honor.
Until the spring.
Yes, Your Honor. And so, but at that moment, when their question regarding the contract requirements for a full clean and coat or a partial clean and coat, at that moment, their project manager has testified that when he wrote that request for information, he believed the contract didn't require a full clean and coat. And he said as much. When I wrote that, I thought we did that first 7% wrong, is what he said.
By wrong, did it too well. They blast cleaned everything. Because
Yeah,
they blast
yeah.
cleaned everything, as I understand.
That they didn't have to.
Right.
They didn't have to do that. Correct, Your Honor. And so the notice for intent to file claim didn't happen at that moment in December. Instead, Atsalis, there was a winter break and they picked up work again in April, and they still fully cleaned and coated the whole structure. For a large part of that, they were doing the interiors of the tie girders, which no one disputes was a partial spot. But then what happened was around when summer began, June, July, they got off of, are you familiar with the Blue Water Bridge, Your Honor?
Oh, yes, I've been over it many times.
Yeah, so there's a large portion that looks like kind of like a highway overpass.
Mhm.
And then you get to the iconic portion, which is all the steel girders, right? So in the summer of 2019 is when, or late spring of 2019 is when they started work on that iconic portion. And then MDOT believes they didn't have, a viable claim because they never filed a notice. So then at that point, Atsalis had sent a letter saying, do you want us to fully clean and coat this still? Are you going to continue to direct us to fully clean and coat this? And the response was yes, you are to continue to fully clean and coat according to the plan specifications. And then at that moment, they filed their notice. And so that was in July of July 23rd, 2019. And they had been fully cleaning coating prior to that. Now, at the time MDOT filed its first motion for summary disposition, many of the facts had not been elicited from the witnesses. A large portion of discovery hadn't been done. But it was MDOT's belief that MDOT's response to that RFI 6, that a question back in December, that was sufficient to put them on notice that they needed to then file a notice. That was the basis of the motion. And the court had ruled, no, MDOT's answer is ambiguous. That's not good enough. Instead, I'm going to look to see if the later notice qualifies as a notice. And it did something somewhat peculiar, because it ruled that that notice was good for the work going forward, but not the work before it. Now, so in reviewing that, you see that based on the limited facts before the court was relying on the affidavit of Gary Manos, who characterized the work after the July 23rd, 2019 notice as different. And it's paragraphs 42 and 43 of the affidavit, of his June 18th, 2020 affidavit.
For the court reporter, Manos, I think is Manous.
That is correct. Gary Manos, Garry. And that was presented in response to MDOT's motion. And that is what the court relied on, that work after that notice was different. And it was an affidavit stating, didn't directly say it was different. It just said, it asked this question, are you going to continue to direct us to clean and coat? It asked it because they were going into the substantial work on the main span.
Right.
And so the court said on the limited facts before it, there seems to be some difference between that prior work and the later work. The later work's on the main span. I don't know if that's different or not. But on the chance it is, I've got to deny your motion because there's a question of fact as to the character of that later work.
And that was a C10 motion at that.
That's correct. And so further discovery has taken place, and it has shown that not only did Atsalis actually begin work on the main span in June, not July when it filed its notice, but in June, but it also shows that all the work was, it also shows that all the work was the same, under the same pay item, using the same equipment. It was all the same work. So if that notice was no good for the work done before it, then it can't be any good for the work done after it. And that's
because the work never changed. In other words, they were doing the thorough job from the very beginning. And your view is the contract required them to do the thorough job on everything. And so from start to finish, what they were doing never changed.
Exactly. So that resolves, Your Honor, the ambiguity the court was faced with based on the limited evidence. But also discovery further revealed that Atsalis knew of MDOT's interpretation well before it sent its letter in July 2019, asking about, hey, what is it you really want us to do on this job? And there's an admission in their response brief, Your Honor. Their own response brief, page 8, admits that when they started work after the winter break in April, that they had discussions with MDOT and said, what is this? And MDOT said, it's a full clean and coat. And it's an admission on page 8 of their brief. And that's when Gary Mena said, well, can we get that in writing? The important point, though, is that there's no requirement that it be in writing. They just have to encounter the circumstance.
What's your theory about why this would have surfaced later on rather than right at the outset? Is it because it was more expensive than they thought it was going to be to do the full job on every part of it? And they realized, oh my gosh, we're gonna come in at a huge loss if we hit the contract price. So can we cut back on what we're doing and just basically spot there?
Yeah.
Whatever the word is.
So Your Honor, I
Spot blast clean instead of blast clean everything.
that is not our current theory, that it was just underbid. While, and this is in the record, when they bid on that job at 8.3 million, they had 2 other major work going on in Connecticut and Massachusetts that employees of Atsalis have testified is their biggest job ever. A $22 and a $23 million job in those states. And so it's MDOT's belief that there was an issue getting to MDOT on time and starting the MDOT project. But furthermore, when they started in December, they had a foreman by the name of Derek Bosco. He's a Polish gentleman who's renowned in the.
Spell that last name for the court reporter. Please. I think it's like Bozkow or something.
Yeah, exactly. The last name is Bozko or Boczko. And he's renowned. Atsalis' vice president of contracts at the time, who had since left but is now back with Atsalis, we believe, by the name of Chris Gatz. He testified that this man has done more for Atsalis than any other person aside from the owners of the company, right? He was just a phenomenal foreman. And our MDOT's painting contractor testified that this guy was many years of knowledge, very good at what he did. And the thing was, Your Honor, is he retired at the end of 2018. And then he was replaced by a foreman by the name of Robert Hunt, who doesn't appear to have the same expertise. And he is the foreman who was in charge at the time when they were cleaning or supposed to be cleaning the interior of the tub girders, yet they couldn't get environmental conditions met. And so they had 8 workers sitting in a bus on the clock waiting for environmental conditions.
So at some point, performance for Atsalis became disadvantageous to them.
I would agree, Your Honor. At some point, it was a situation where the cost to complete this and the liquidated damages they were facing were going to be severe. It's important to note that when they first showed up late, they asked to work through the winter. Normally, liquidated damages would have been applied, but MDOT, in an effort to work with the contractor, waived those liquidated damages. But then on the second event, when the next contract season went and we were looking at the contract not even meeting its final deadline, at that moment, liquidated damages were not waived. And so the liquidated damages that you see are applied in that time period.
Was that the $138,000 or something like that?
Correct, Your Honor. Yeah.
And just to be clear about it, that number shakes out in the final account. The liquidated damages are applied.
That's right, Your Honor. They were applied before the final balance of around 500,000.
And when you say that they were nowhere near completing by deadline, I think when you terminated for convenience, they were just over 50%. Right?
Correct, Your Honor. We had recorded through.
You overlapped the judge. I didn't hear the end of what he said. They were just over 50% what?
Completed.
Okay. Please wait until he's finished, everybody, please.
Yes, Your Honor. So our records show about 52% of that work, that blasting work. There's other items that have been completed because this there's various bid items on the contract. And so there's various bid items that were completed. There's various bid items that were not even started, and there's various bid items that were partially completed. The blast cleaning bid item was recorded at 52% complete. And that was at the end of 2019. And actually by the contractual completion date of January, I believe 10th or 20th, 2020. So it's MDOT's position that this is not a motion for reconsideration because the court's prior order was specifically, it was a denial of some partial summary disposition on that count based on a question of fact. And specifically, the court notes, the court doesn't say, well, this fact contradicts you. The court says, based on the evidence before it, it's unclear what the character of that second work was.
Well, let me ask you this, Mr. Tuttle, because procedurally, Judge Redford and I were talking about this on a drive up here a week or two ago, that we get these serial motions for summary disposition under C10, and the ground keeps shifting underneath our feet. And so we keep getting these motions as more and more discovery takes place. And now discovery, as you told me, is still open. So why don't I deny this motion as premature? I mean, additional evidence could surface as we go forward.
I would say additional evidence is very unlikely to come forward. I won't 100% say it won't come forward, but there's no dispute that MDOT's interpretation applied to the entire pay item. So MDOT's interpretation of the contract was that pay item, and that pay item applied to all the work done. They were paid for that work under that pay item.
I get it, but I mean, I hope you appreciate the concern that two very experienced trial court judges have, that we keep getting these C10 motions, and at the time you show up and argue, you say, the record's complete, you can make a decision. Oh, there's a genuine issue of material fact. Okay, now we've got more discovery. Now let's try it again. Now let's try it again. I mean, we would have exploded if this would have happened in the circuit court where we have to get cases closed in 2 years.
Yeah. Yes, Your Honor. I would like to make clear that although there are 5 motions for summary disposition, this is the only part of any of those motions that's based upon a further factual evidence in regards to a prior incomplete record. The other ones, for instance, MDOT's first motion for summary disposition didn't touch on many of the claims.
I appreciate that. And
Yeah.
I'm not being critical of you, Mr. Tuttle. I'm just saying that for us, gearing up for C10 motion after C10 motion is pretty demanding, particularly when this is really a moonlighting job for us.
It is understood, Your Honor, and I will remember it when
Thank
filing
you.
such motions in the future. But I would like to stress, I think there's different circumstances in this case, in these motions.
I understand that, but please
Yeah.
understand that I spent hours last night plowing through everything. And if I get another C10 motion in this case, I'm not going to be happy about it.
We don't anticipate any more, Your Honor. So that is count 2, the blast cleaning claim is specifically on this notice. And it's important because the main issue is whether or not the work was any different before the notice and after the notice. Because if the work was different after the notice, then conceivably the court could say, well, I understand why there was not a notice for this work, but I cannot say that it needed the notice is late for the prior or the post work.
But just to be clear about this, your position is they were doing it right in the first instance. They were just going way too slow.
Yeah, our position, they were doing it right from the very beginning. Our position is that they knew of MDOT's interpretation from the very beginning. And our position is also that even if you wanted to say the work was different after July or based on that notice, in other words, the work with the main span was different from the work with the previous spans. The facts are that they started that work on the main span in June. So they're already late. Even if, in other words, no matter how the facts would have fallen, whether we're right that the work was all the same or the work was somehow different, no matter how those facts fall, their notice was late. And at this point, it's based on facts that can't reasonably be disputed because it's based on facts from Atsalis's employees.
Got it.
Yeah. Now that's for count 2. As for count 3, and 4, they are essentially the same count. So I believe count 3 is a misrepresentation and count 4 is a breach of implied warranty of accuracy. And those are both, the implied warranty of accuracy is also a misrepresentation claim.
Yeah, one of the things that struck me is count 3 sure seems like it'd be wiped out by the economic loss doctrine, but maybe I'm reaching on that one. But in any event, we're talking about the Scotch code, right?
That's correct. Yeah.
And that's it.
Yeah, and so Scotch code is a separate code. It's not part of the main paint that was applied to various spots of the bridge. Atsalis' contention is that it's an anti-abrasive and therefore it's harder for the blast to remove it. Evidence from MDOT's from various witnesses, but particularly MDOT's inspector, who has the highest painting inspection certification, and he's not an MDOT employee, but just a contractor, was that it doesn't take any extra time to remove it. But that's a factual dispute right there. Is it harder to remove or is it not? Acknowledged. But that's not what MDOT seeks to have these counts dismissed as. Count 3 and 4 are misrepresentation claims that are based on a misrepresentation of a site condition. In other words, the bridge, the site, had a differing condition than what was said in the plans. MDOT's position, it doesn't differ. They were put on notice that Scotch coat was there. They never misrepresented how much. They didn't say there was a little or a lot. They just said there was portions. And Atsalis' position is that portions is understood as just a little bit. And
So just to be clear, the problem at most is one of degree, not of kind. They were aware that there was Scotch coat on there. Whether it was 2% or 98% isn't specified.
correct, Your Honor. So there's also the damages proof issue there. How much was included in the contract that they had to pay, that they had to do just based on their bid, and how much is quote unquote extra work? That's not the basis of MDOT's motion per se. In the second section of MDOT's motion, it's just based on notice. Because these claims, these misrepresentation claims, they have been codified by the contract. MDOT standard specifications codified the notion of differing site condition. There's a lot of case law out there, and it primarily relates to underground conditions. So in other words, these claims came about because MDOT would have someone build a road. They would go out and they dig up the ground to prepare to build the road, and they would discover a giant boulder that they couldn't move with standard equipment. Or there would be some sort of condition that they didn't factor in when they bid. And so the court cases came to the conclusion that, well, you can't rely on this bid then, and they need some compensation. It's a valid claim. Eventually, that got codified into MDOT standard specifications, and it's known as a differing site condition claim. That claim, that differing site condition claim for Scotch coat, was part of count 2. It was part of count 2, and it was dismissed in count 2 for untimely notice. And so MDOT's position is it's the same claim, because it's just a codification of the common law one. They brought it as an alternative under common law. It's really the same thing. They're not allowed to add their claims afterwards. There's an exhaustion requirement in the contract. So they brought it already. It got dismissed for lack of timely notice. They can't expand. That's why we think under section 2, 3 and 4 should be dismissed for lack of timely notice. And then section 3, Your Honor, is that we believe 3 and 4 should be dismissed for a failure to keep track of their damages, or a failure or an inability to prove their damages, which they have essentially admitted to. So the contract requires them to keep track of what is alleged extra work. Like, what did you do based on the contract? What did you do that was alleged extra?
Right, I understand. So essentially, even if they prevail on liability, they're not going to be able to do anything on damages more than speculate.
Yeah, exactly, Your Honor. And in light of the fact that evidence has come out that they were incredibly inefficient at times on this job, paying workers to sit in a bus for 8 hours, it would be highly prejudicial to MDOT to have to pay based on speculation to cover those costs. And so that's essentially 3 and 4. And we believe the same problem, although we did not move for it, Your Honor, to be clear, we did not move for it. That same problem with inability to prove damages exists for the blast cleaning on count 2. There's no records of what was allegedly bare and rusted steel and damaged coating and what was allegedly extra work.
Talk to me a little bit about what's left in terms of recoverable damages on count 1, because when I read the complaint, my initial reaction is we have a straightforward breach of contract claim in count 1. And usually everything that follows behind that is going to be wiped out by the fact that you've got enforceable contract rights, whether you call it unjust enrichment or fraud or anything like that. It's either unavailable as a matter of law or it's wiped out by the economic loss doctrine. So if they go to trial on their best day, what can they win on count 1?
So, Your Honor, we don't believe much because as the court has interpreted count 1 is that when there's a termination for convenience, right in 108.12, right up front, it says that the engineer, meaning MDOT, can elect to pay for the work that was done based on bid prices. And so at that moment, if in the example of a road, they're supposed to build 100 miles, they only build 50 miles, but those contracts are based on road foot.
And just to be clear about it, they had already been paid something like more than $4 million, right?
Yes, Your Honor. So this was a lump sum contract. It's very difficult to calculate percentages of work on painting a bridge. And so MDOT's practice is to do it as one lump sum. However, what they allow the contractor to do is propose what's known as a schedule of values. And those schedules of values are this portion of the bridge we're going to call 7%. That would span 1. This portion of the bridge we're going to say is 15%. And so as they complete those milestones, MDOT releases payment.
So those are just progress payments. I mean,
Exactly.
in common parlance.
Yes, yeah. But this was a lump sum amount. And so progress payments were made based on the percentage completed. But no record of any of what was allegedly extra work is ever made. Instead, Atsalis' hope is really under its count 1 claim. Its theory of the case is that the termination for convenience converted the contract from a bid price contract to just cost reimbursement. So any cost they incurred, to be frank, Your Honor, we got bills for iTunes charges in the packet for costs, right? It was any cost that they had that they incurred on the project. That's contrary to the plain language of 108.12, which says that the engineer can pay on bid prices. So the court has determined no, the engineer can't pay on bid prices. Where you get just the costs are for pay items that weren't started yet. And now Atsalis has argued that's impossible because if you haven't started it, there's no cost. But that's just not true in the construction industry because you often rent equipment to do a job. So the idea behind the direct cost portion, 103.02, is that say you never started the work, so you can't be paid any bid price, you can't be paid a progress payment because no progress was made, yet you still have sizable costs because maybe you rented a crane, you bought material. Those costs can be paid out as a direct cost under the termination provision. But if you actually did the work, then MDOT can pay bid prices. And so the question for count 1 is what work was completed, what work was partially completed, and what work wasn't even started. And that'll determine how it gets paid. And that was what was done on the claim. They submitted all their costs. MDOT's engineer went through and said, well, this is a cost under that pay item. All the work on that pay item was done. We paid them all the progress payments. They don't get that cost. This portion was only completed to 52%. They get 52% of the bid item. This portion here wasn't started, and this is a cost that looks like they can be paid. And so after all that work was done, it was a very lengthy process because it was 17,000 pages, I believe, of material, or maybe it was 1,700, but it was a lot of pages. And after it was fully combed through, it was determined that after subtracting progress payments, there was still 500,000-ish costs left to be paid.
And just to be clear, so I can get a preview of this for trial, the contract price was over 8 million, but not a whole lot over it. They'd received over 4 million. And I think that the bulk of the $500,000 was essentially just packing up their stuff and leaving. And so your view of it is, what it amounts to is they got paid about half of what the contract price was.
In essence, Your Honor, yes, it was, I believe, 8.3 million for the bid, and I think it was either 4.2 or 4.6 in progress payments. They did half the work, they got half the pay. But I don't believe that the 500 was actually paid for packing up their stuff. So once the contract was terminated, all their stuff was still there. They had to do what's known as demobilization. Demobilization was paid under a different contracting mechanism known as a force account.
Okay.
And that, so far as we know, there's been no allegation that the force account figures were wrong, that MDOT didn't pay under the force account. And so what's at issue is what they were paid for the work prior to the termination.
Okay, that's fine.
Right. Thank you, Your Honor.
Thank you, Mr. Tuttle. Mr. Vittilio, come on up, and as soon as you get to the microphone at the lectern, I'll be glad to hear anything you want to tell me.
Well, thank you, Judge. So obviously you've received extensive briefs. You've got
Yes.
a ton of evidence here on a C10 motion. I think that we laid out our position pretty succinctly in that we've given you affidavits, we've given you deposition testimony on what led to the timing of the notice of intent for the special blast cleaning. And we've given you the legal argument that we believe is the correct approach, in that nowhere in this contract does it require the contractor to provide a special blast clean on all of the steel. They can't point to it because it doesn't exist. And therefore, what we argue and what we believe is the correct approach is that once HNTB finally had the guts to put it in writing, yes, you are directed to provide a full blast clean on all the steel.
Mhm.
We treat that as a revision to the contract under the standard specification 103. Hence, that is what we view and argue as the circumstance giving rise to the claim.
Help me with this, though, because it seems to me that other than the fact that prior judicial decisions in this case have limited what you can do in count one, I presume when you started this case, you figured you could get everything you needed out of count one, right?
Well, absolutely, based on what the standard specs say on count one.
Right.
Right.
Right. And everything else was just kind of belt and suspenders. You had to lead some backup positions, but
Correct. And that's, when you read 108.12 and it talks about circumstances that the contractor encounters in the performance of the work, and for reasons beyond the control of the contractor, or for reasons beyond the control of the department believes in its best interests to terminate this contract for convenience. And hence, the legal argument to your predecessor was, okay, the department said when they terminated this contract for convenience, in their termination letter itself, it provides that we are going to compensate you for partial work performed under the lump sum pay items that are at issue under section 103.02F. That's what their letter says.
But stop for just a second and help me make sense of your number, because I'm not saying I buy their number, but I understand how they got to the $4 million plus in progress payments plus about $500,000. As I understand your client's approach to this, it's the $4+ million in progress payments and then another $12 million on top of that for half the project. Help me make sense of that number.
So-
It seems high.
Well, it seems high in a vacuum potentially, but that's why we have put in front of Your Honor and in front of the department the relevancy of the special blast cleaning project that just completed.
Right. So in essence, what you're telling me is, even though you want twice as much as the contract price for doing half the work, that's mostly attributable to the fact that the blast cleaning was far more comprehensive than you anticipated. And this Scotch coat removal turned out to be a big problem that you hadn't anticipated.
Yes, correct. And yeah, and while the number does seem high, we do believe that the evidence shows that, I mean, the records are the records as far as their certified payroll, as far as the equipment costs. I mean, I can't speak to an iTunes charge. I don't know off the top of my head, but the fact remains that reading MDOT's termination letter in and of itself and reading the book, and the book, when it talks about we're prevented from proceeding or completing the contract work for reasons out of our control, namely, the department realized that its contract documents as bid did not describe the intent of what they wanted. And so what we say is, okay, you terminate for convenience, you have that right. But you can't just shun away the fact that we've incurred these impacts.
But just to be clear about this, then, your client's understanding going in was that there would have to be spot blast cleaning, and this Scotch coat was going to be a minor inconvenience.
Essentially, our client's understanding as bid is based on the documents as published. And so one point that Mr. Tuttle brought up is, just like any other contract, it's a full blast. Well, that's a real important point, because this isn't like any other contract. A bidder needs to look at the unique special provisions, and that's what they're unique to the job. And so that's all a bidder has. So as Atsalis reviews the bid, Mr. Atsalakis reviews the bid, he sees the special provision, he sees the limitation so that the special blast cleaning, which is unique in and of itself, only applies to areas of bare and rusted steel and damaged coating. So that's what formed the basis of the bid.
But when your client started out, it sounds to me like they were blast cleaning everything. As a matter of fact, they give you credit for doing a really good job of it.
Right. Yeah. And there's no dispute in that. I mean, we concede that. Those are the facts, and the facts are unique, to be sure. I mean, we've come to you with the evidence and the deposition testimony saying that there was miscommunication amongst Atsalis. There was miscommunication between the individual that bid the job and the people running the job.
Yeah, this just strikes me as a case that's quite different than what I've usually seen in construction disputes. Usually in a construction dispute, the allegation is the contractor is doing terrible work, and so you have to throw them off the job site and somebody has to come in and clean up the mess. The way I understand this case, your client showed up and was doing a bang up job. They were doing a great job, but the difficulty was it was taking them longer than anyone had anticipated, and it turned out to be a much more complicated process.
Yeah, essentially, Your Honor, I mean, their inspector, their daily reports, they all confirm that Atsalis performed the work as they wanted it performed. It's just not described in the contract. And so, part of the difficulty here is the hampering of the prior opinions, because
Right.
A big part of this case, Your Honor, is also the temporary work form and platform containment issues that aren't even up for today. But so when you bring up the point that it wasn't moving fast enough, correct, it wasn't moving fast enough. And a big part of that was because the inability of Atsalis to gain approvals in connection with its platform and containment submittals, which is another issue, Your Honor, that you asked us at the very outset of this afternoon, whether it's at issue. It's not, but I just, it's a big part of the case in and of itself. So, you know, I look at the reply brief that was filed in connection with a C10 motion, and I don't see where that really slams the door on why there's no genuine issue of material fact here. I mean, we take the position that you've got the evidence, namely, well, you did point out an important point that discovery remains open. It does. They need to take a key deposition of Mr. Atsalis, who bid the job, so he may have more evidence to, you know, give on this topic. But in connection with the reply brief in and of itself, you know, to rely on Bart Catone and, you know, it's all pretty much speculative hearsay, and I just don't see how that helps in the connection with a C10 motion. You know, Mr. Catone is testifying that Darius Bosco would not have made a mistake. Well, okay. Well, we've given you evidence on why Atsalis did what it did. I mean, it may not make a lot of sense to you, me, or Mr. Tuttle, but the facts are the facts. And so those facts are not, are uncontradicted. The other point that they raise in the reply brief is reliance on a corporate rep dep for a bonding agent that, you know, he testified that the client anticipated a change order coming. You know, if nothing else, that helps us. I mean, that shows that Atsalis thought that a change would be coming, you know, a work order or a change order would be coming. And so, you know, we feel that at the very least, there's issues of fact with respect to timely notice. Or, you know, we've just asked that you deny them. I mean, we did give timely notice based on the evidence that we've presented. We did raise a couple other arguments with respect to the notice, and these have been arguments that I've been bringing up for 5 years now, but I might as well take the chance and just raise them one more time. In that, once the notice of intent was provided, the department and Atsalis agreed jointly to submit the issue to the DRB. So this you're asking about the DRB. The DRB is there from the inception of the project through the end, and its purpose is to have specialized individuals with knowledge, former MDOT reps, former contractors, that can help and guide the contractor and the department to resolving disputes.
But they don't have any final decision-making authority, as I understand it. I mean, it's no different than going to facilitative mediation. You can get a terrific mediator, but the mediator can.
That's right. At the end of
can't resolve it.
At the end of the day, Judge, what they do is once a formal claim is submitted, which is what Atsalis did, once a formal claim is submitted and the engineer presumably denies the claim, then you appeal to the DRB. Then the DRB will hear it. No lawyers are allowed. No lawyer. So they'll hear it and then they make a recommendation. And it's a recommendation. And so once that recommendation is rejected, then the administrative remedies under the contract are exhausted and then the claimant can bring suit. One other point on the notice issue is that we've put emphasis on the fact that as this project was nearing the end of the second construction season, with only 50% of the work being done, the department told Atsalis, you need to submit a claim. Not a notice, not a notice. You need to submit a formal claim. And you have to do that as a condition of coming back to work.
I understand.
Okay. And
Yep.
so we've taken the legal position, Your Honor, that, you know, that's not something to sniff at. I mean, you typically, you submit a claim once the work is done. And Atsalis was performing that work per the satisfaction of the MDOT and its inspectors. So, you know, with all of that, Your Honor, I'll answer any other questions you may have, but we'd ask that you deny the motion.
Thank you. Appreciate it, Mr. Tilio.
Thank you.
Mr. Tuttle, I'll give you each one more round. I'm going to try to let you speak without too much interruption this time. The only thing I ask is that you not go for a half an hour. I think I understand the problem.
Thank you, Your Honor.
Excuse me, Judge. I need to get somebody to cover a 3 o'clock Zoom. I have a 3 o'clock, so I gotta get somebody to call the office. Can we take like a 5-minute reset?
Sure. We'll stay up. We'll keep the link up and we'll come back in 5 minutes. You just let us know when you're ready to go. Can't imagine we'll go past 3 o'clock.
Judge, if you think I can make the 3 o'clock Zoom, I don't have to drive anywhere. You could.
Okay, yeah. I promise you, I'm looking for no more than 5 to 10 minutes from each side.
Okay.
Finished.
Okay, so go ahead.
Mr. Tuttle, I'll invite you back up to the lectern and why don't you go ahead and tell me what you had to say in response to what Mr. Vitilio said.
Thank you, Your Honor. I think your understanding of the case or the work progression is not entirely accurate, Your Honor. It is correct that MDOT did not have an issue with the work that was done, but it wasn't an issue that the work was more complicated than expected, maybe with the temporary platforms, which they could not submit a design that satisfied safety requirements. But the real problem is they showed up 8 months late. They showed up 8 months late after the whole construction season had come and gone, and they were busy trying to work in the winter.
Right, and for what it's worth, if you heard me say something to the effect that you were thoroughly satisfied with everything, I get that the problem wasn't the quality of the work, but the pace of the work.
Correct, Your Honor. Regarding Atsalis' position on 108.12, which it stressed again here, the court has already, one, ruled on that, and two, Atsalis continually ignores the actual language of the provision when it lists the reasons under which a contract can be terminated, because it states reasons for termination may include, but are not limited to.
Right. Look, if you're going to talk to me about 108.12, it seems to me that if it's termination for convenience, I know what termination for convenience means. It means you don't have to have a really good reason to do it.
Yeah. Yes, Your Honor. And I'd like to point out too that MDOT's motion, as I know you understand, but I'd like to just put it on the record. MDOT's motion is based on notice, not contract interpretation of the special provision. And it was Atsalis' burden to rebut that, and they just haven't done that. The other thing is that Atsalis puts its entire case as to understanding of the contract is on this notion of the contract as bid, and that the only employee opinion that matters is the gentleman who bid on it. The gentleman who bid on it is George Atsalakis. He was not involved in the work. He did not go to the mandatory pre-bid meeting that explained the work. He didn't go to the pre-construction meeting that again explained the work. And there's plenty of evidence that George, the project manager, the foreman, everyone else understood that it was a full clean and coat. And I would like to point you to Upjohn Co. versus New Hampshire Insurance Co. That is 438 Mitch 197.
438 Mish 197.
And it's a 1991 case by the Supreme Court, which states in which they adopt the principle that the combined knowledge of the employees may be imputed to a corporation. So their position is that, well, you shouldn't listen to the people who were doing the work. You shouldn't listen to the man who signed the contract, Tony Atsalakis, who testified he believed it was a full clean and coat. You shouldn't listen to any of them. Instead, you should listen to George Atsalakis, who bid it, who only came in when this situation arose, when they were far behind, and one of their own foremen told MDOT's inspector that they found something in the contract. And that's when all of this notion of this change in language crops up. And it was said it was all speculation or it was hearsay, but these are all statements against interest by a party opponent. So they all come in. So I don't believe it's correct for them to rely solely on George Atsalis and somehow say, well, this is what it was bid as. They understood the contract. But again, that's really not an issue in this case. I address it solely because of the prior argument of Mr. Vitilio. Again, regarding the DRB, you correctly identified that it's totally advisory. But I'd also like to put on the record that the chairman of the DRB testified that the DRB's opinion, the advisory opinion, was favorable to MDOT's interpretation. So why they keep relying on the DRB, we're not entirely sure. And as regards the GMCG, I'm sorry with the acronym.
Okay.
It's known as the Liberty Maintenance Contract that
This is the successor.
Yes, the one that completed all the work in a year. Now granted, they had better weather conditions, but still they didn't leave guys in a bus waiting for 8 hours for what conditions to improve. And there was a special contracting mechanism where certain issues got worked out. This contract was advertised and it was let under the notion that the contractor must have the ability to submit plans for rigging and containment. That's all his bid and said it could do it. And evidence shows they couldn't. They had some outrageous ideas. One was to take a scissor lift and raise it all the way up in the air. But in order to, you have to contain the work because when you're blasting off the paint, you can't let it go everywhere. And you can't let the blasting material go everywhere. So they submitted a plan where they would take that whole structure and put it in a tarp. Well, now the wind can blow against the tarp. This is in MDOT's inspector's testimony. It was dangerous. It's not workable. So while they can claim that there's all these requirements that made it unworkable, part was in fact because when they proposed their ideas, they were unworkable. So I believe that's all I have to offer. And regarding the waiver about the claim.
Right. When you said submit a claim.
Yeah, when we said submit a claim, at the very beginning of this, MDOT asserted that that was basically a protected MRE 408 negotiation. We did have to explain the matter though, because it was raised in a waiver issue. And we still maintain it, even though there are briefs that mention it. We maintain that it is protected, but in any event, the court has already ruled that there's no waiver there. And it was a negotiation. I'm sorry, the Liberty Maintenance Contract, one last word, Your Honor, and then I'm done. And that is, as we mentioned in our brief, the reliance on any cost figures in that contract are wholly unreliable due to massive construction inflation that has happened since COVID, due to a different scope and a different contracting method.
Right. As I understand it, your view is apples and oranges.
Exactly.
They were contracted to do all sorts of things that Atsalis wasn't contracted to do.
Yeah, and we would like to say if that becomes an issue, Your Honor, we're going to need an expert to counter and to at least to show the construction cost increase over the years. Oh, all right. That's all I have, Your Honor.
Thank you, Mr. Tuttle. Mr. Vitilio, you get the last word.
Your Honor, unless Your Honor has any questions, we'll stand on the brief in our prior presentation.
Thank you. I think I'm all set.
Okay, thank
I
you.
don't know what the answer is yet, but I'm certainly all set. I know as much as I can possibly know. Thank you both very much. Really appreciate the presentations today. As I told the people at 11 o'clock, I'm going to write a comprehensive opinion here, if for no other reason than as a roadmap for either me or my successor on the Court of Claims, if this is around for yet another judge to resolve. I want somebody to have a clear path to the end of this case, because civil litigation, this sort of thing is a means to an end, not an end in itself. So my goal, if I can do it, is to get this one across the finish line. But if I can't, I want to make sure that whoever picks it up next understands exactly where it's left off. Sure.
We did, you asked council about trial dates.
Yes.
When we were in front of you on a status conference several months ago, we had tossed the idea of a mid-July trial date. I mean, that would be our preference. I mean,
Well, let me put it this way. Somebody has now taken July 14th and blocked a week on my schedule.
okay,
So it would be August if it were going to go to trial this summer.
okay, that's all. I just wanted to address that. You brought it up earlier and I.
Sure. Look, nothing would make me happier than to be able to get this case cleaned up in a matter of months. My goal is to try to clean up my docket to the very best of my ability. Okay?
Thank you.
Thanks, everybody. I really appreciate it. To the court reporter, thank you very much for hanging in with us. We're finished and we can go off the record now.
Do you need this, Judge?
I'm sorry?
Do you need this transcript?
Yes, please. Yes, please.
Want this one too? Okay, thank you.
Thank you very much. Really appreciate it. Okay, and we're not